Hi everyone, welcome back. Part 3 and the final part for this lecture. I know we've covered quite a bit. So I'm going to kind of go over some of the laws that you need to be aware of and how they apply to you as healthcare professionals and as future pharmacists. But let's go over the answers to the quiz. So the first question was, which one of the following may result in a criminal prosecution? So the answer is D, because A, B, and C are civil matters and not criminal matters. So D, sale of a P medicine by a pharmacy student from a pharmacy where there's no pharmacist working, that would be seen as a criminal act, a breach of a criminal law, and would be seen as a criminal prosecution. Question 2, pharmacy student is caught by the police supplying cannabis resin to 4 of his non-pharmacy friends on the university campus. What's the maximum prison sentence that a magistrate's court in England could impose? So as I said to you before, with magistrates that don't generally impose anything more than 12 months, on average it's about 6 months, so that his answer is B. Please note, cannabis is a class B drug. It's not medicinal cannabis in any way, so there is a distinction between cannabis resin and for use for non-medicinal purposes. So cannabis under this scenario would be considered class B, and that's quite a penalty. So although the magistrate's court would potentially impose a sentence of 6 months, as a pharmacy student, you'd also be put under fitness to practice investigation and hold up for intent to supply. So that would be criminal prosecution as well as a FTP, fitness to practice procedure. Okay, now there's a whole bunch of laws that you need to be aware of or certainly know in the next few years. So I'm not saying you need to know all of this now, but we will cover some of these in one way or another. And this is not the full list, there's quite a lot that apply in various ways, but we will cover some of these, as I said, in the next few years, okay? But they are important in one way or another, either as a pharmacist or as a pharmacy owner or employer, these laws apply, okay? But what I want to do is briefly go over the Medicines Act and the Human Medicines Regulations and a few other key regulations and acts that are important and that you need to be aware of kind of from the outset, I would say. The Medicines Act is, as I've said before, it's an act of Parliament. It comes under statutory law, and a breach of the Medicines Act comes under criminal law as well. So it's an act that governs the control of medicines for human use, and it includes manufacture, importation, sale and supply of medicinal products. It also includes the registration and conduct of pharmacies. It doesn't cover veterinary medicines because that comes under the Veterinary Medicines Regulations 2013. Now the Medicines Act has been superseded by the Human Medicines Regulations. So quite a few years ago, people revised the Medicines Act and then created the Human Medicines Regulations as a result. However, the Medicines Act is still relevant and is still in place. So the key difference, I suppose, is that the registration and conduct of pharmacy still comes under the Medicines Act. So it hasn't gone away, but it has been superseded by the Human Medicines Regulations. And this is really comprehensive and again governs medicinal products for human use, and that's manufacture, import, distribution, sale and supply, labeling, advertising and pharmacovigilance. So it's a little bit more encompassing than the Medicines Act used to be. Okay, so that's something to be aware of. So what does the Human Medicines Regulations cover? It's a whole bunch of things. So as it says, we will cover over the next few years quite a bit of this, but you do need to be aware of it. So it defines what a medicinal product is. It covers the licensing of medicines, and that's really important because we need to be aware of how medicines are licensed, particularly when it comes to prescribing of these medicines and the implications of prescribing something that's licensed versus unlicensed, which does happen because there's different risks associated with that. And as pharmacists, we do sometimes give out medicines that are not licensed. So that's, as I say, has its own implications in terms of safety and efficacy and liability. So under normal licensing, something will come under a UK marketing authorization, and that's just a way of proving that a medicine is both safe, efficacious, and has quality. And that gives us, not certainty, but certainly assurance that when a medicine's out there, it's going to do what it's purported to do. So it's going to be safe, efficacious, and the quality is good. Okay, so licensing is quite key, and you'll hear more about that in due course. There are certain exemptions to marketing authorizations. So by law, pharmacists are still allowed to prepare unlicensed medicines in a registered pharmacy. So it comes under Section 10 of the Medicines Act and Regulation 4 the Human Medicines Regulation. So as a pharmacist, we are actually allowed to compound medicines still, so produce medicines from scratch if we have been directed to do so by a practitioner or a prescriber. Okay, so as pharmacists, we don't really do that so much, but within hospitals, you may have aseptic manufacturing units, and then you also get specials companies who do that. And as a pharmacist, we are allowed to manufacture medicines if there is a prescription for it, for example. Okay, don't see much of it these days, but in the old days, you used to be able to make tinctures, liquids, suspensions, suppositories, pessaries, things like that. But we don't. You'll get some element of that within the first year. So one of your lab practicals, if we're still running it, I can't remember if we're still running it this year, but that's about compounding medicine. So we do have a specific exemption under law to be able to do that. So coming back to that unlicensed medicines again, usually if it's a one-off preparation in accordance with a prescription or preparation of methadone. So this is a medicine we'll cover in the next couple of years. You'll hear more about methadone within the second year when we cover misuse of drugs regulations. But this is a drug that's used for the treatment of addiction, to wean patients off kind of the harder drugs. And methadone can be given out quite in large volumes. So and the way that it's prepared can be seen as an unlicensed medicine. And then something called chemist nostrums, which is basically something that's used based upon our own judgment. And that's usually for the purpose of selling over the counter, and it's not a prescription only medicine. So this could be a simple preparation for example, just soothing the throat. So it could be a cough linctus, or it could be something like a simple lotion. So calamine lotion, for example, for treating kind of itchiness or mild rashes. Again, very rarely see that these days, but we do have the facility under the Medicines Act and the Human Medicines Regulations to make these products and sell them over the counter. Human Medicines Regulations also cover the sale supply of non-prescription medicines, so that's GSL and P medicines. So again, these will be covered in more detail in due course. And also POMs, which are prescription-only medicines. It looks at selling medicines to the public at a distance, so this is online pharmacies, and particularly falsified medicines come under that. Covers import, export, clinical trials, everything to do with packaging and labeling of medicines. So all the packaging of medicines is strictly controlled. Labeling is, again, how we label medicines is dictated by law. And by law, every drug product has to have a leaflet, a patient information leaflet in it. And again, this will become more apparent as you start to do your dispensing classes, but all of this is dictated and covered by the human medicines regulations. They also control homeopathic medicinal products and herbal medicines as well. So they do control the regulation for supply and sale of these products. They also cover things like borderline products, which are not strictly medicines, but can be used for treatment of conditions. They also cover advertising, which we'll cover next year. Publication of the British Pharmacopoeia, which is a nice compendium which tells you all about medicines, when they're used, gives you guidance around manufacture, and gives you monographs for each types of sort of testing and manufacturing of medicine. So you'll come across the BP, the British Pharmacopoeia, again over the next few months. And then pharmacovigilance we'll talk about again in the next, you'll get introduced to it next year, and we'll follow it with it in part 3. But this is about monitoring medicines after they have been released to the public. So although medicines are sort of generally deemed relatively safe when they're released to the market, sometimes when a wide range of people start using them, you start picking up additional side effects that you didn't pick up during the clinical trials. So pharmacovigilance is continual monitoring of medicines after they have been released to the general public, and it's a really important process and mechanism that we as pharmacists can feed into. So it's just continual monitoring of medicines. And then enforcement. So we've already talked about the MHRA and the powers that they have for enforcement, and we'll talk briefly, mention that again in a second. Something that is new this year is the Medicines and Medical Devices Act 2021. So you will have heard me talk about the EU law before, and how before Brexit we took on board the EU law and then incorporated it in our own ways within our own statutory laws and within the sort of human medicines regulations and other kind of medicines related legislation. So the kind of act that enabled us to do that was the European Community Act 1972, but that got abolished just before we left, or just before we started the proceedings for Brexit. And this act had provided the powers to amend that EU legislation that had been introduced in the UK. So because obviously we're out of Europe now, and since that act was abolished, the government has come up with a new act, which is called the Medicines and Medical Devices Act 2021, and that basically provides powers to amend the human medicines regulations, the veterinary medicines regulations, and the medical device regulations. And we'll talk about we've already kind of alluded to these regulations earlier on, and there's still work to be done on this, and we still need to figure out how relevant this is to, or what impact this will have within pharmacy. But one of the things that the Act is expected to provide powers to is to be able to permit independent pharmacists to outsource dispensing, something called hub and spoke dispensing. So it's not something I'll cover within this lecture, but you will hear about that in due course, and it's a movement towards removing the dispensing process from pharmacies, and then kind of effectively sending that to a hub or a kind of big center where all the dispensing is done, and once that dispensing is done, it's sent back to the original pharmacy. So the hub would be one central place where all the dispensing is done, and the spoke would be the individual pharmacies that send the prescriptions to the hub, and then once the hub dispenses the products, that dispensed product goes back to the spoke or the individual pharmacy then to give out to the patients. So this is a new model that's being proposed, and it's already operating now within the UK. So some kind of chain pharmacies do operate a hub and spoke type dispensing service, and that is something that there's a little bit of a push for within the pharmacy community to kind of move towards, to allow pharmacists to be freed up and not have to worry about the dispensing within a community pharmacy, and then give them the time to actually do different services. So that's something just to look out for in the future, but it's worth just bearing in mind that this is a new act that's occurred this year, and it does allow various changes to be had to the human medicines regulations, etc. Here we are, really, enforcement of medicines legislation. So as I say, the MHRA are the UK's body of enforcement. They're the ones who look at licensing, manufacturing, wholesale dealing. So this is where it's commercial supply of medicines. So sale and supply of medicines commercially, advertising, promotion, import, export, clinical trials. So the MHRA govern all of that. So they are the ones that look after the UK medicines legislation. And then the GPHC, their role within medicines legislation is registration, operation, and inspection of pharmacy premises and all aspects of retail sale and supply of medicines. So that will include control and supervision. So we've already talked about cases where there has to be a pharmacist on the premises in order for P medicines or pharmacy only medicines to be sold and supplied. And also quality, labeling and packaging. So whenever we dispense a product, we are responsible for labeling a prescription only medicine before it's given out to a patient. So that again will be partly governed by the GPHC. So they will look into that as well. So that was a bit of a whirlwind tour of the human medicines regulations. As I say, there's various aspects of that which we will cover over the next few years. So things like, as I say, the manufacturing, the licensing, classification of medicines, all of that will be covered in due course. And you just need to be aware that all of that does come under the human medicines regulations, and any breach or any breaking of those rules means you've breached the human medicines regulations, which is comes under statute law, and it will be seen as a criminal act. So anything that we do against the human medicines regulations is seen as a criminal act and will be prosecuted and dealt with accordingly. So that's quite important to bear in mind. Okay. So that said, it's one thing that pharmacists are always scared to do is make a dispensing error. And a couple of years ago, the pharmacy preparation dispensing errors registered pharmacist order came about. So to give a little bit of background, one thing that we drum into you and all pharmacists are scared of is making a dispensing error. And unfortunately, people do make errors. It's human nature to make errors. Nobody's saying that you're not going to make an error. But one thing that we need to be mindful of is learning from making errors. So unless people report these errors, then we're not going to know that they're happening, and we're not going to be able to support or put processes into place that will minimize any further errors. So what happened was that if you made a dispensing error, a lot of pharmacists didn't actually report that or make note of it, such that there was no way of actually improving on it. And the reason they didn't report it is because they were scared they were going to get into trouble. So there was that fear of prosecution within the profession. So one thing that came about was that this new order came about, which provided new legal defenses to prevent the automatic criminalization of inadvertent dispensing errors. So if you made a dispensing error, you've basically faced a triple jeopardy when you commit a dispensing error. And that triple jeopardy is basically, if you make a dispensing error, you're guilty of an offence under the Medicines Act, and you're also in a possible breach of the criminal law if it leads to death of a patient, and also you are under professional regulation sanctions, i.e. the GPHC. So if your fitness to practice was impaired, then you will then be put up in front of the GPHC. So it's triple jeopardy. 1, you breach the Human Medicines Act. 2, if a patient comes to harm or dies, it's a criminal law you breached. And 3, you may get in trouble with the GPHC under fitness to practice. So making a dispensing error is not trivial, so you can understand why pharmacists are fearful of making one and reporting one. But what this new order does do, it does give you a defense to prevent automatic criminalization. So as long as you can demonstrate certain things, you won't automatically be prosecuted for making a dispensing error. You need to be mindful of is that the defense can be used when the dispensing error occurred in a registered pharmacy, was by or under the supervision of a registered pharmacist or technician working in that role, was when supplied against a prescription or a patient group direction, which you'll learn more about next year, emergency supply or direction from a prescriber, and the key thing is has been promptly notified to the patient once the pharmacy team are aware of the error. And that's what that comes under is something called duty of candor. And that duty of candor is basically taking responsibility for when things go wrong. So it's being open, being transparent when things go wrong and letting the relevant people know. So that's quite important. So we need to take all reasonable steps or show that we've taken all reasonable steps to make sure that error is not carried further and that nobody comes to harm. So that's the key point. So a defendant, so if you make that mistake, you'll only be acquitted by proving the above conditions are met. It doesn't apply at the moment to non-registered premises such as hospital pharmacies, but there's plans to introduce similar measures here, and it doesn't apply to dispensing errors of over-the-counter medicines. Okay, I mean, in reality, prosecutions to date for dispensing errors are quite rare, and they've only really been brought about in the most serious of cases. I think pharmacists are generally quite good. If they make an error, they deal with it in the proper way, but the key thing is trying to help promote reporting of this and not feel that you're going to get into trouble for making a record of it, because at the end of the day we have to learn from our mistakes, and if we don't learn from them, we're just going to be making the same mistake over and over again. And I think as a profession we need to know what the common ones are such that things can be done to change it, and it could be just a change in the practice of how we do things. Okay, look at some scenarios of how you might deal with a situation. So the first one is a pharmacist dispenses the wrong drug of a medicine with the potential to cause serious harm on a Friday afternoon. So they've made a dispensing error. It's a Friday afternoon. Okay, it's got potential to cause harm. So on their way home, the pharmacist realizes that they've made that error and telephones the pharmacist to see if anybody's still there, but finds that everyone's gone home. So they basically leave that matter until Monday. But unbeknownst to the pharmacist is that the patient is hospitalized over the weekend. So based upon what I've said, do you think the defense, the new defense, applies to this pharmacist? So have a think about it. Have a look at the previous slide if you want. But do you think under this particular situation, the pharmacist would be eligible to receive that defense? Okay, so under this particular circumstances, the pharmacist hasn't discharged their duty of candor promptly, so they haven't contacted the patient immediately. So they have so they can't benefit from the defense, even if on the Monday they tried to contact the patient before they became aware of the hospitalization. So if they dealt with it on Monday, okay, you could argue that they didn't know about the hospitalization, but if they deal with it on the Monday, they still won't benefit from the defense. They needed to have dealt with it when they knew about it. So the new defense would mean that they would need to return to the pharmacy on the Friday and take all reasonable steps to contact the patient. That's the only way that they would be able to use the defense. So they can't leave it to the Monday. They'd have to go back on the Friday and make sure they can make all attempts, reasonable attempts, to contact the patient. Okay, now let's kind of spin it a different way. So what if in the above case, the pharmacist is not sure whether or not an error was made and leaves the matter until Monday? Does that change the situation in any way? So again, have a little think. What do you think? Would the defense still be, would they still be able to use the defense if they were not sure and still left it until Monday? Now you could argue that because they don't know if an error was made, they could still benefit from the defense, but that is really behaving unprofessionally. If there's any doubt, they need to really deal with it. The added thing there is if a court decides they would have deliberately failed to have due regard for patient safety, then the defense will not be made available. So the argument there again is if you're not sure, you need to go back and check. Don't leave it until Monday. So again, they would have to return to the pharmacy on the Friday and take all reasonable steps to determine whether they've made the error or not. And if they have made the error, then they need to try and contact the patient as a matter of urgency. Okay, so the third scenario is, well, what if the error is made by a pharmacy student who is acting under the supervision of a pharmacist? So on their way home, the student realizes that they've made an error and contacts the pharmacy, and the pharmacist of the pharmacy owner is still there. So what about that situation? What do you think might happen here? Okay, if the pharmacist or the owner fails to act, so if the student contacts them and speaks to them, but they don't do anything about it, then all three people, and that's the pharmacist, pharmacy owner, and the pharmacy student, they will not benefit from the defense. Now, if the students exercised all due diligence to avoid making the mistake, and the mistake is actually done due to the default of another person, then they have the defense. So what I mean by that is if the students made all efforts to try to avoid making that mistake, and that mistake wasn't then later picked up by the pharmacist because they are the last point of check, then it could be that they could then benefit from the defense. But as I say, it all comes back down to anybody with a duty of candor, and these are all health professionals, have an obligation to notify the patient as soon as possible about that mistake. And if you do that, then you do have that defense, and you won't automatically be under criminal prosecution. So it's quite important. So hopefully that gives you a bit of context as to why this new order is quite important, and that as long as you show that duty of candor and that due diligence and contact the patient as soon as possible after making a mistake, whether you think you made one or not, then that gives you a defense. Okay, so the other thing as well you need to be aware of, and we kind of briefly touched upon it within the Welcome Week icebreaker, is this idea about confidentiality and data protection. So the Data Protection Act is really important, but within the Data Protection Act, you've also got the General Data Protection Regulation, or GDPR. Now, patient confidentiality and data protection are in the top 5 areas that pharmacies fail during their inspections. And this was the last couple of years ago, and that still applies now. So pharmacists aren't always exercising their due diligence in terms of confidentiality and data protection. And this is important to pharmacy in a number of ways. So this is things like when you deal with their prescriptions and you keep a patient medication record, that is data protection. Giving information to other people about patients, or saying things about your patients to other people who haven't got the permission, when you haven't got the permission to do so, that's under confidentiality. Providing access to medical records to other health professionals, that's again comes under data protection and confidentiality. Posting things on social media about a patient you've seen that makes them identifiable, again, that comes under confidentiality and data protection. There's a lot of different ways in which the data protection and GDPR applies. Okay. Under the GDPR, anybody processing personal data must have a lawful basis for doing so. So there has to be a valid lawful reason for collecting somebody's data and keeping somebody's data. So that's really important. And when we talk about personal information or personal data, we talk about things like name and address, date of birth, their medical condition, their treatment, their email, their telephone number. That's all personal data. And when it's concerning health, then there's this extra level of security that's needed, because that's a special category of personal data, and it can only be used or processed for the provision of healthcare or treatment. It can't be, that information cannot be given out for anything except for healthcare or treatment. Okay, so this is quite important. So there needs to be a valid reason why you need to process personal data. And for pharmacy, there are lawful bases for doing this. So if we are covered as pharmacists to collect that information, to be able to process that information, and there is a lawful basis for doing so as a pharmacist. So we need to be a bit mindful of that. The other thing to be mindful of are patients' rights as well. So this is not the same as the Human Rights Act. These are different rights. So these rights are quite important. These are patients have several rights to their data, and patients' rights must be notified to patients at the time their data is collected, and must be in a language that is clear, concise, and easily acceptable. So basically these rights, so patients have the right to be told their data will be processed. So they have a right to be informed that we are keeping their data. So this is a privacy notice typically. So within a pharmacy, they should have ideally a notice, a privacy notice, that tells them that we are keeping their data and the lawful basis for keeping that data. Okay. But patients also have the right to access their data free of charge. They also have the right to erasure of their data if it's no longer necessary for the purpose for which it was collected. And they also have the right to withdraw consent to processing. So that's if consent's a lawful basis for collecting that data in the first place. So remember, if somebody gives you consent to do something, they also have the right to remove that consent. So that's quite important to bear in mind, and we'll talk more about consent in due course. But there are certain rights that patients do have in relation to any personal data that we keep about them. Okay, so they need to be told we're keeping that data. They have a right to access, they have a right to remove it. There's a few other rights as well, but these are the kind of some of the key ones. And in a pharmacy, we can certainly make sure patients are aware of the right, in terms of the right to be informed, by either displaying notices such as the privacy notice or publishing the information in a practice leaflet or on a website. So these are quite key things that we need to be aware of. And again, as we go through the MFARM, you'll get to see how this is kind of implemented, but you do need to be mindful that, you know, when somebody does give us information, particularly personal information and that health related information, we are obliged to protect that information and not divulge it unless there's a legal basis to do so. Okay, so, and this is where you have to be careful about who you tell or where you post that information or divulge that information. And for any public authority, there needs to be a data protection officer. So this is somebody who's generally independent of that company, but this is somebody who you can speak to about GDPR, about data protection and the do's and don'ts. So every pharmacy or every pharmacy chain should have a data protection officer. So if you're not sure about whether you're breaching data protection or what to do regarding data protection, then the data protection officer is somebody who can be contacted, and there'll usually be contact details within the pharmacy and certainly available to patients should they need to contact them for any reason. And there have been cases where patients have contacted the data protection officer because they felt that the pharmacy has breached data protection rules. Okay. And that kind of conveniently takes us to professionalism online. So again, we've touched upon things you need to be careful about when you communicate to people online, excuse me, and post things online. So online activities can be quite important for pharmacy business, because usually that's where you're going to tell them about what services you provide, get people to register with them so you can do their repeat prescription service and all that kind of stuff. But it's quite important that what you do and what you say on the online is considered quite professional. So we have the same responsibilities and obligations when interacting online as we do when we do face-to-face. So when using social media, the GPHC expects you to use good judgment and behave professionally. Think about expectations and perceptions of patients and employers as well. So don't forget, potential employers can have a look at your Facebook or Instagram or Twitter feeds, and they can make a judgment based upon what you've said and see if you've acted professionally or not, or certainly are able to act professionally. Be aware that anything you say online can potentially be copied and redistributed and taken out of context. So that's quite important. Challenge poor behaviors and raise concerns when needed. So that's quite a key thing to do. If you see somebody who you think is acting unprofessionally, then it might be a case of challenging that behavior and raising concerns where necessary and to the right people. But the key thing is maintaining confidentiality and privacy at all times. What you do is bully, harass or intimidate, unlawfully discriminate, post inappropriate comments, share information about patients or their care, that's a big no-no, and get drawn into negative or unconstructive discussions. Basically, think before you post, particularly now that you are pharmacy students. Remember, the standards of our pharmacy professionals apply to you, so anything that you do now can be taken potentially and used against you if you are acting unprofessionally. And the last thing, just again, this is a little bit of an aside, but we probably won't cover this anywhere else, so I'm covering this now, is the Medicines Device Regulations 2002. This is really just an awareness that any kind of medical device, and that could be considered an instrument, apparatus, appliance, software, anything that's used either alone or in combination for diagnosis or therapeutic purposes or both, has to be regulated under the medicines device regulations. And this covers things like intrauterine devices, which are used for contraception, dental fillings, contact lenses, dressings, things like that, blood pressure meters, anything like that, basically, test kits, that kind of stuff. And there's regulations that put into place obligations on manufacturers to ensure that the devices are safe and fit for their intended purpose. So basically, the medicines device regulations ensure the safety of these types of devices. And the way we can ensure whether they're safe or not is to check if they have a CE mark, which is a conformity mark. So this CE marking allows the placing of the devices on the market in any EC member state. Now again, post-Brexit, I'm not sure what's happening with the CE marking, but certainly that's a good way for us to know whether that device is actually fit for purpose to use and is safe to use. So if you are using or selling devices, then a medical device, should I say, then you really need to see if they've got the CE marking. Otherwise, you can't guarantee that they are safe and effective to use. So it's a mandatory conformity mark that indicates the manufacturer is satisfied that the product conforms to all relevant essential requirements in legislation. And it's the MHRA that administers and enforces this legislation. So at the moment, the CE mark is still valid. So I don't think that's going to change, to be honest. And the MHRA might just administer that domestically rather than certainly EU. But I think anything coming in from the EU would need to be also checked. Okay, so I've just got another couple of questions here. So I won't, the answers are on the next slide, but have a look, think about those. And then, as I say, once you've done that, have a look at the answers on the next slide. I think they're fairly self-explanatory in terms of what the answers are, and don't need any further explanation. But good luck with everything over the next few weeks, and hopefully I'll interact with you at some other time. But in a nutshell, as you can appreciate, law and how we certainly practice as a pharmacist is regulated in a number of different ways, and we need to be mindful of all of these different ways in terms of what we do, how we do things, how we interact with people, and so on and so forth. So law doesn't go away. I'll give you a tip now. Learning it now doesn't mean you forget about it next year or the year after that. You will always be tested in law, whether it's the second year, third year, fourth year, pre-reg or beyond pre-reg. Law does not go away, and you need to keep on top of anything that we provide you in terms of that. It gets updated quite regularly, so you need to be keeping abreast of all this information. But you'll make sense of it as we go through things. So thank you guys for paying attention, and speak to you soon. Bye.